1. Offer. A. Definition. Offer. An offer in contract law is a clear, unequivocal statement by one party, the offeror, expressing their willingness to enter into an agreement on specific terms, with the intention that it will become binding upon acceptance by the other party, the offeree. B. Elements of an offer intention to create legal relations. The offeror must intend that the offer will result in a legally binding agreement upon acceptance. Definiteness and clarity. The terms of the offer must be clear, definite, and certain. Communication. The offer must be communicated to the offeree. The offeree must be aware of the offer to accept it. C. Types of offers. Express offer. Clearly stated terms, either orally or in writing. Implied. Offer. Terms are inferred from conduct, actions, or circumstances. Unilateral. Offer. An offer made to the world at large, inviting anyone who performs the specified act to accept the offer, e.g., a reward offer. Bilateral offer. An offer made to a specific person or group, involving reciprocal promises between the offerer and offeree. D. Termination of offers. Revocation. The offerer can withdraw the offer at any time before acceptance, provided the revocation is communicated to the offeree. Rejection. The offeree can reject the offer, after which the offer cannot be accepted. Counteroffer. A counteroffer by the offeree constitutes a rejection of the original offer and creates a new offer. Lapse of time. Offers can expire if not accepted within the specified time or within a reasonable period. Failure of condition. If a condition attached to the offer is not fulfilled, the offer terminates. Death or incapacity. The offer terminates if the offerer or offeree dies or becomes legally incapacitated before acceptance. E. Special offers. Invitations to treat. Statements or advertisements that indicate a willingness to negotiate but are not offers capable of immediate acceptance, e.g., a store's display of goods, advertisements. Auctions. The auctioneer's call for bids is an invitation to treat, and each bid is an offer. Acceptance occurs when the auctioneer signifies acceptance by, for example, dropping the hammer. 2. Acceptance A. Definition. Acceptance. Acceptance in contract law is the unqualified agreement by the offeree to the terms of the offer, thereby creating a binding contract. B. Elements of acceptance. Unconditional agreement. Acceptance must be unequivocal and correspond exactly with the terms of the offer. Communication of acceptance. Acceptance must be communicated to the offerer, unless waived or implied. The method of communication, e.g., in writing, verbally, or through conduct, can be specified in the offer. Timing. Acceptance must occur while the offer is still open and before it has been revoked or has expired. C. Methods of acceptance. Express acceptance. Clearly stated agreement, either orally or in writing. Implied acceptance. Acceptance implied through conduct or actions consistent with the terms of the offer. Postal rule. Acceptance is effective when the acceptance letter is posted, not when received by the offerer, if the postal rule applies and post is an acceptable means of communication. D. Silence as acceptance. General rule. Silence typically does not constitute acceptance unless the offeree takes the benefit of the offered services with a reasonable opportunity to reject them and with knowledge that payment is expected. Prior dealings or agreements between the parties indicate that silence can be considered acceptance. Legal principles and case law. 1. Communication of acceptance. Feldhaus v. Bindley, 1862. Silence does not constitute acceptance. In this case, the plaintiff's claim that silence was an acceptance of the offer was rejected by the court. In Torres Lanti v. Miles Far East Corporation, 1955. Acceptance must be communicated to be effective. In instantaneous communication methods, e.g., phone or email, acceptance is effective when received by the offerer. 2. Acceptance by conduct. Brogden v. Metropolitan Railway, 1877. Acceptance can be implied through conduct. Here, conduct showing that both parties acted as if a contract existed, constituted acceptance. 3. Postal rule. Adams v. Linsell, 1818. Established the postal rule, where acceptance is effective upon posting the acceptance letter, provided post is an acceptable means of communication. 4. Counteroffers Hyde v. Wrench, 1840. A counteroffer constitutes a rejection of the original offer and is a new offer. The original offer cannot be accepted after a counteroffer is made.